Good day, sir. I am Adrian Asombrado from Section D. For today's video, I will answer the questions which serves as our final examination in CLJ 400. Number 1. Define evidence and explain its scope. Revise rules on evidence. Rule 128, Section 1. Evidence is the means. Sanctions by these rules of asserting in a judicial proceedings the truth respecting a matter of fact. A scope of evidence shall be the same in all courts and all trials and hearings, except as otherwise provided by law or these rules. Number 2. What are the three kinds of evidence? Briefly explain each. The three kinds of evidence are object or real evidence, documentary evidence, and testimonial evidence. Real evidence are evidence that are tangible, object or sounds recording of a conversation that is offered in evidence. Documentary evidence consists of writing or any material containing letters and words. Testimonial evidence, an evidence in court of law that cannot be supported by physical evidence but is provided by credible witness under oath. Number 3. Distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from the various sources but proves a common point. Meanwhile, in the cumulative evidence is a additional evidence of the same kind and character tending to prove the same point. This is purely the accumulations of similar evidence that is derived from common sources. Number 4. What is prima facie evidence? Prima facie evidence, which is, if unexplained or contradicted, is sufficient to sustain a judgment in favor of issue it supports. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of a party that offers the prima facie evidence. Number 5. What is the dying declaration? What about statement altered as a part of the res gestae? According to Section 38, dying declaration is a declaration of dying person, made under the consciousness of an impending death, may be received in any case wherein his or her death is a subject of inquiry, as evidence of the cause and surrounding circumstances of such death. Statements altered as a part of the res gestae is a statement made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto. Under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as a part of the res gestae. 6. What is the order of examination of individual witnesses? Briefly define each. The order of examination of individual witnesses are direct examination by the proponent, cross-examination by opponent, redirect examination by proponent, re-cross-examination by the opponent. Direct examination is questioning of a witness by the lawyer side party that called such witness on a trial. A cross-examination is the act of the opposing party questioning the witness during a trial. Generally, a witness is initial questioning by the party who called them to the stand on direct examination. With direct examination, with the proponent means to afford the party calling the witness to explain or amplify the testimony given on a cross-examination, to explain apparent contradictions or inconsistencies, and to rehabilitate the testimony. Re-cross-examination by the opponents is the questioning of a witness who has already provided testimony under oath in response to direct examination, as well as cross-examination by the opponent. Number 7. Brief explain what is judicial affidavit. Judicial affidavit is a statement of witnesses given under oath, intended to take the place of their testimony in court given during direct examination. It is written out of court statement taken before a notary public or any persons authorized to administer oath. Number 8. An offer of compromise in criminal cases is in applied admission of guilt. What are the two exceptions? First exception is in a criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by the law to be compromised. An offer of the compromise by the accused may be received in evidence as an implied admission of guilt. The other one is the plea of guilty, later withdrawn, or an unaccepted offer of the plea of guilty to the lesser offense is not admissible in evidence against the accused who made the plea offer. Number 9. In order for evidence to be admissible, it must be relevant and competent. When evidence relevant, when evidence is competent. Evidence can be competent when evidence is relevant if it has a relations to the fact in issues as to induce belief in existence or non-existence. Competence, in addition to relevance, admission, evidence must also be competent. Under the Rule 128, Section 3, evidence is competent if it is not excluded by the law or these rules. Number 10. What is leading question when it is allowed? A leading question is a question that suggests a particular answers and contains information the examiner is looking to have confirmed. Leading questions are generally not allowed on direct examination, except to develop a witness's testimony. Number 11. What is the misleading question? A question which suggests to the witness the answer which the examining party desires to leading question. A misleading question is one which assumes as a true fact not yet testified to by the witness, or contrary to that which he has previously stated. Number 12. When the circumstantial evidence sufficient to sustain a conviction. Circumstantial evidence sufficient to sustain a conviction when there is more than one circumstance. The fact from which the inference are derived are proven, and the combination of all the circumstances is such as to produce a conviction beyond a reasonable doubt. Number 13. Distinguish burden of proof from burden of evidence. Burden of proof is the duty of a party to present evidence and the fact in issues necessary to establish his claims or defense by the amount of evidence required by the law, while burden of evidence is a duty of a party to present evidence to establish rebut a fact in issues to establish the prima facie case. Number 14. What is the standard of proof necessary? Civil cases, the party having the burden of proof must establish his or her case by the preponderance of evidence. Criminal cases, the accused is entitled to an acquittal unless his or her guilt is shown behind the reasonable doubt. Number 15. Administrative cases, briefly define each. In administrative cases, a fact may be deemed established if it is supported by substantial evidence or that amount of relevant evidence which is a reasonable mind might accept as adequate to justify a conclusion. Number 16. Define what are the public documents. Public documents are A. The written officials' acts or records of the sovereign authority, official bodies and tribunals, and public officers whether of the Philippines or the foreign country. Letter B. Documents acknowledged before a notary public except last wills and testaments. Letter C. Documents that are considered public documents under treaties and conventions which are enforced between the Philippines and the country officers. And letter D. Public records kept in the Philippines of private documents required by law to be entered therein. Number 17. In 17, how do you prove the present in court private documents? By the means of letter A, by anyone who saw the document executed or written. Letter B, by evidence of the genuineness of the signature or handwriting of the maker. Or letter C, by the evidence showing its due execution and authenticity. And number 18, the original document rule statement states that when presenting a document as evidence only, the original is admissible. What are the four exceptions? Letter A, when the original is lost or destroyed, or cannot be produced in court without the bad faith on the part of the offerer. Letter B, when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by local judicial processes or procedures. Letter C, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only general result of the whole. Letter D, when the original is a public record in the custody of public officer or is recorded in the public office. And lastly, letter E, when the original is not closely related to controlling issue. Number 19, who can become a witness? All person can be perceived and perceiving, can make known their perceptions to others, may be a witnesses, religious or political belief, interest in the outcome of the case or the conviction of a crime, unless otherwise provided by law, shall not be ground for disqualification. And lastly, number 20, when it is an extrajudicial confession sufficient to sustain a conviction, an extrajudicial confession made by the accused shall not be sufficient ground for conviction unless corroborative by evidence of corpus delicti. That's all, sir, and thank you.